Let me first focus on the community property, community issue. Freddie, before we zoom into some of the features of community issues affecting an Indonesian marriage, could you briefly explain the what the term community actually means, and then elaborate on the basics of Indonesian community property rules?
Okay, thank you, Joe. So I think before we start with what is a community, better we start with what kind of law applicable to the Indonesian individuals. In Indonesia, that when we talk about the regulation on the individual relating to the marriage and inheritance, that's affected by his or her religion or his or her ethnic. So because in Indonesia we have several regulation on different type of religion for the personal matters like marriage and inheritance. So in this case, we would like to only focus on the regulation based on the civil code that and married law on 1974. So this is to make it more focus on this particular law. So now we start in the community. So basically, any single spouse that married and they do not sign any prenup or postnup agreement, so the assets post married would be constituting as a joint property or community assets or community property here. So that's the basic or the fundamentals idea. So unless they sign the prenuptial that govern otherwise, all assets after the marriage become jointly owned.
Okay, thank you. So do the Indonesian community property rules apply to inherited property of one of the husband or the wife, or do they apply to the property that was already acquired before the marriage?
Okay, basically the community property apply of course after for the inheritance as well. So let's say the husband passed away and the husband has an asset, let's say 100. So we need to take out first the portion of the community property. Let's say the community property, let's say 50. So the inheritance only on the remaining 50.
Okay. You mentioned a prenuptial agreement. Could you, just for those non-lawyers among us, could you briefly explain what a prenuptial agreement is?
Okay.
Whether it's legally effective?
Of course, thank you. The prenuptial agreement, yes, that's fully recognized in Indonesia and start governed since 1974. So basically, this is the agreement between the spouse. They sign before and start applicable as of the marriage valid by the law. This is something that the agreement that will govern how the ownership of the assets after their marriage. So anything they already have before their marriage, not subject to this, basically not subject to this prenuptial agreement. In 2015, the Indonesian Constitutional Court issued a decision to give an opportunity for the post agreement.
And that's basically the same as the prenuptial, but for those couples who never signed the prenuptial agreements. Okay, let's go on to the next questions. Freddy, can Karina claim community rights over property that has been transferred to a foreign trust, like in this case the Hong Kong trust that you can see on the top right?
Okay, so basically the spouse that not excluded based on the prenuptial agreement, they have the 50% of the other spouse assets. That's the basic principle. So the asset that transfer to the trust, for instance, the asset is cash in bank in, let's say, in Singapore and transfer to the trust, and this one, and then they got divorced, for instance, and what happened with the assets that's in under the control or possession of the trust? Yes, this one can be disputed or can be would be subject to the community property.
Okay, clear. And Zach, question for you: does the Hong Kong trust law give any protection against a community property claim?
Generally, Hong Kong would follow the sort of common law system, and within common law systems, although we generally don't have community property, so it's the same in Singapore, UK, Australia, etc. We do respect community property from a foreign jurisdiction. So from the Hong Kong trust perspective, you would look at whether or not Hong Kong had any applicable firewall legislation to defeat a sort of spouse's claim to half the assets transferred into the trust. Generally, well, in Hong Kong, there is no firewall protection against community. And it's probably worth mentioning that generally the international financial centers that do have advanced trust laws, they generally do not seek to defeat community property claims. And the basis of that is because community property really is a proprietary right by virtue of the effective marriage domicile. So it's not a sort of right that's been given by a discretionary court order. These are proprietary rights by virtue of the marriage domicile. And in this case, the marriage domicile would be Indonesia. It has community property, assets transferred into trust, effectively post the marriage or celebration of the marriage would be within the community. And therefore, it would be a right that would be subsumed within the trust. So Hong Kong trust law doesn't provide protections against community property claims, and indeed many of the other jurisdictions, Cayman, etc., also do likewise. They don't seek to defeat proprietary claims against assets transferred into trust.
Thanks. And if you look at this particular case, the 75% indirect holdings of the trust in the Indonesian trading company, how would that be protected or respected?
I think this is, it's really down to if you can trace through the trust, which is what effectively I think Hong Kong will do. The question here is whether or not the sort of Indonesian court would short circuit all of that and seek to apply community directly against the proportionate share of the Indonesian trading company. And I think for Freddie, this might be one for you, Freddie, is whether or not an Indonesian court would seek to disturb corporate structures in this way to recognize a personal right in Karina, let's assume, for her community property claim in assets that had been transferred into trust originally.
Yeah, I think the asset that transfer to the trust, including this example, let's say the trust indirect shares 75% in Indonesian trading company. When the transfer happen, the transfer should follow the community property relevant regulation that the wife should give the spouse consent, in short. So the transfer not in compliance or in absence of the spouse consent may be subject to the dispute or claim by the wife that 50% of that belong to the wife.
Right.
Thanks. We go on to the next, please. John, John, a question for you. Would the US recognize a foreign community property claim?
Yeah, thanks, Joe. I think the important thing to understand here is that the US treats these community property issues on a state-by-state basis, not federal, the way that the federal tax system works. Now, there is a separate state tax system, but there is an overarching federal tax system. There is not from a community property perspective. So absent a contention, absent someone challenging it, the answer to the question would be yes. The US would tend to respect the community property decision that has been reached by another jurisdiction, regardless of the state, tend to. If there's a contention, though, the states vary widely in their definitions of marital property, and they may not align with the Indonesian definition that's been achieved. So you might have a contentious issue. It's best to go ahead of time and identify the relevant jurisdictions where either property is located, like the land, immovable property, or property where it's temporarily movable, where you've got that bank account, maybe you shift it to a different state or outside of the US to avoid that conflict issue.
Okay, thanks. And Zach, what about the BVI? Do they recognize foreign community property ownership?
Yeah, so the BVI would apply UK common law principles. They would recognize the matrimonial domicile. And if the matrimonial domicile held community in property ownership, then the BVI law would respect that. So that they would look at the ownership of the BVI shares as being subject to whatever the community was in the source jurisdiction. So yes, I think for Karina in this case, were she to take an action in the BVI to recognize her community rights, then the BVI would apply UK normal common law principles. And a lot of these principles are quite old cases, old and dated cases. So they hark back to different eras, but generally they're consistent. And even though some of these cases look at the community property rights also extending not only to movables like a share, but also to immovables like land. And so there's a famous UK case with a South African couple where it also was found that the community property extended to UK land and not just to movable assets. So yes, the BVI would apply UK principles in the ordinary way, looking at the matrimonial domicile to recognize that.